Good morning from Israel, and early morning in the UK, all the way to afternoon and early evening through India, Japan. So I'm glad everyone could make it. We're clearly in a very strange situation in terms of not being able to meet each other internationally at the normal venues. But then, of course, technology always finds a way to bring along new solutions which enable us to do something like this. And we're very pleased that we can share a short time with you in what is our morning and whatever time of day it is where you happen to be. Hopefully we'll learn a little bit more about the patenting process in Israel. I would add that, again, some of you are old friends, some clients that we do work with, some from Israel, some from around the world, and it really is a very diverse group that we have here. But the one thing is that everyone, I believe, has an appreciation of and an interest in how patents and patent applications work in Israel. Before I start my actual introduction, I'd like to, well, actually, a comment even before that is that I'm going to be relating to a lot of numbers. I know it doesn't sound that I've got the right profession. Maybe there should be more a seminar in accounting, but it is the right one. A lot of numbers that I've discovered come into what I want to say. And the first actually is 1,800. And I'm referring to 1,800 years ago. There was a place in northern Israel at the time called Tzipori, which is where one of the major works that is still studied today was written, called the Mishnah. And one of the sayings that appears there talks about people who are wise, someone who has wisdom. And it's actually very fitting for our profession, and it's very fitting for the time that we're in. The phrase in Hebrew is Ezu Chacham Haro'et Hanolad. Who is a wise person? Someone sees that which is, shall we say, going to be born, something which is about to come. And of course, we know that if any of us had prophecy, we would really understand, we'd actually be able to make quite a lot of money off of it. We'd be able to know all the inventions that are needed. We'd know how to resolve all the problems of mankind, even before they start. We don't have that. However, in our profession, we know that what our clients are developing is one eye on today, or maybe half an eye on today, but the rest of their vision is for tomorrow and for the day after. And this is clearly something which is, again, has always been true of our profession, but even more so during this current period where every day is something different. Okay, so I am going to resume the screen sharing and proceed with my own introduction. Okay. By the way, I would just add that at any time, please feel free to send me a message with a question, and at the end, we will proceed and answer hopefully most of the questions. So a brief introduction about who we are, JMB DAVIS Ben-DAVID. So if you look on the left here, so that's a much, much younger picture of me 25 years ago, together with my late father, Dr. Stanley Davis. He was a chemist and a patent attorney. And together we founded the firm on which the current practice is based. That was back in 1995. It was done in Israel. The satellite picture is a view that people often don't have of the country, and it's of some interest. That's the Red Sea at the bottom. The Nile is that long snaking river over to the left, finishing the Nile Delta. And you can actually also interestingly see that the top part of Israel, which my cursor is on, is green, and the bottom part is desert, which connects through to the Sinai Desert and into Africa. Anyway, that was a digression. The firm was founded, it was started in 1995 in Tel Aviv. It lasted there for about a year, and then proceeded to move to Jerusalem, to the current park where we're located in 1996. The building there is our current location where we've been for 6 years. Around about the same time we moved into this new building, Dr. Mike Hammer joined us to set up our US practice. And therefore 2013 is the date next to the United States. In 2020, we not only have celebrated our 25th anniversary, but we also have a new logo, which you can see. The Davis here is obviously the connection to my late father, Dr. Stanley Davis. And over to my right in the picture is Avram Herman, who is also a new partner this year. So, very briefly then, so what do? We do more or less what many IP firms do, but we certainly have our specialties. Over on the left, as you can see, I've attempted to portray the connections that we have with firms that we've worked with in the past, still working with all over the world. This is in all areas of IP, patents, trademarks, and designs. In the areas of patents, as you can see by the icons that I've shown here, there are very few areas in which we are not occupied. As a traditional Israeli firm, we obviously file cases in Israel Patent Office, but as from 2013, under Mike's careful navigation, we since then have been filing cases in the United States as well, directly from our premises in Jerusalem. So that, in a nutshell, is who we are. And I now wish to move on to the reason why we're here. So first of all, what are we going to have? We're going to be having 5 things. Okay, the first is an overall introduction by me. Okay, then we're going to get a brief discussion by Evyatar Aaron, who is an Israel and US patent attorney, on basic stages of how you apply for a patent, what's required. This is going to be the outline. Before we get onto what I regard as the real meat of this entire seminar, Mike, who, as you may recall, is a US patent attorney, is going to give a slight twist, if you like, in terms of what happens when you have claims you really love in your US case, which many people do, and you want to, and especially in life sciences, and you want to take those, shall we say, round US claims and insert them into this square hole, which is Israeli patent practice. So Mike will be discussing that for a few minutes. Then controlling speed of examination will be presented by Avram Herman. Avram is an Israel patent attorney and a US patent agent, and he's a chemist. And he will be discussing certain techniques which will enable everyone to take advantage of allowances and grants that they've received in other jurisdictions, particularly US and Europe, but not only. That, of course, has significance when it comes to time and cost. Here, there's me again. And with that, we'll be wrapping up the session. So without further ado, okay, so we're not giving prizes to the first person to solve this expression. It doesn't even look like a real geometric expression. These two numbers, 9 and 20, have significance as to the question, why patent in Israel? And I will explain. One major reason why patents are filed in different countries in the world is because of the market size. Israel has been growing considerably, but is still only a market of 9 million people. Therefore, very, very few companies are registering their patents in Israel. There has to be another reason, though, and we'll get to some statistics in a couple of minutes. There has to be a reason why are there certain companies that register their patents in Israel to start off with. And for this, I want to take a bit of a broader look at the Israeli economy and business. And I want you to remember the number 20. Okay, I'm providing these numbers in large font and one at a time, so and hopefully that should be okay. 20. Many people have heard of the World Economic Forum. Among other things, they meet in Davos once a year. And they also produce a report, which is called the Global Competitiveness Report, once a year. And in doing so, they evaluate every country in the world for competitiveness. And the question is, what do they take into account? Well, here I've listed a number of attributes that each country has to have in the right amount in order to be considered competitive. I won't go through all of them. I think one of the major things, though, is on the bottom left. You can see entrepreneurial failure is okay. In Israeli culture, it is almost I wouldn't say required. It is a considerable, almost a considerable honor that when you tout success, to say, well, I actually failed several times. I grazed my knees. I got banged up a little bit, but I'm okay now. And here I've dusted myself off. And this current venture is now a success. So in business culture, failure is okay. You just get up and you carry right on. And something else which is actually quite pertinent for the current times is to embrace change. How much do businesses adapt? I can say I won't, because I could talk for quite a long time about this. But I know that certainly in our own business, we're embracing change. We've adapted tremendously. I think many of us are speaking from our home offices now, not necessarily our actual offices. And this is something which maybe a year ago would have been considered for most people inconceivable. That's just one small example. The fact we're using Zoom to connect people from around the world is also quite, a few months ago, it would have been, something like that would never happen. Today, we're all doing it. The one other thing I want to point out is venture capital. Because of the interest in all of the activities in different fields of technology and business in Israel, there traditionally has been a tremendous amount of venture capital available. Over the years, it varies. Some of the times it's local investors, some of the times overseas investors, but this interest is growing. A lot of the, shall we say, corporate financing of new ventures in Israel, in incubators and accelerators and so on, used to come mainly from the US and Europe. These days, far more is coming from China, from Japan, from India. And this essentially is a reflection of the way that the economic world is developing. I see I have some more people who want to come in. I'll admit them all. Okay. So if we now continue, I mentioned the competitiveness ranking. I mentioned the number 20. And of course, we all want to see where am I in any particular picture. So if you're from Israel, as some of us are, we are number 20. And remember, this is, it's important to see who are the countries that are above. Here's Simon, Australia's 16. So you're obviously doing something right over there. But UK, of course, is number 9. So Rob and Vicky, that's good for you. Japan is even higher. So we all want to find ourselves, and certainly for for Israel, we're very pleased to be number 20. We're up ranking. Sometimes it's important to see, well, not necessarily who's above you, but who is below you, which means what are we doing right? Clearly, you also look above to say, what do we need to do even better? It will be interesting to see how these rankings change a year from now, as of course the whole world economy is in flux, as everyone is aware. Now, okay, and don't worry, this is not a memory game. I'm not asking anyone to remember these 10 companies whose logos appear here, but the companies are typical of something, which we'll have a look at. I would just say, and this is really giving it away, when you come to patent in a certain country, in any country, especially one which isn't an automatic destination, such as these days, I would say automatic destinations are going to be the US, Europe, and China, for example. With other countries, it's always going to be a question as to, do I actually want to invest money in patenting there? These are companies who have all patented in Israel. In fact, numbers again. I'm not going to discuss these numbers on this slide at least, because what do these numbers actually represent? They represent, I would say, the basic statistics of companies filing in Israel. You'll see there's these are the numbers for 2018, which are the last available numbers that I was able to locate. So there were a little bit less than 7,500 applications in total in 2018. A whopping 87% from overseas. Excuse me, were from overseas. This is significant because anyone that looks at the statistics will see that Israeli companies traditionally file overseas more than they file in Israel. Maybe in a way that's a cultural thing. There are obviously business reasons as well, but it's a fact. Okay, the companies before were the 10 top ranked companies who file in Israel. Although I would say that, to be fair, while they are representative of three main field groupings, which I'll get to in a second, they represent a tiny proportion of the overall filings. The bottom line is no one is filing a lot in Israel. I would say the largest number of cases that any single company is filing in Israel is maybe 60 something. So it's not a lot. And that therefore means that you have many different companies who for various reasons are, I would say, doing tactical filings in Israel. And that clearly will depend on the particular interests in business and research and development. So here, just to put things a little bit in perspective, to sort things out, these are the same 10 logos, company logos that you saw before. And if you look on the left, 65% are in the two classes represented by human necessities and chemistry and metallurgy. The chemistry and metallurgy, the only representative here is BASF. All the others, as we know, are life science companies. Physics is a surprising 13% when you consider that physics is normally going to be things to do with communications, semiconductors, and so on. And all the rest take 22%. Again, all the rest is a diverse group. The only two companies to make it into the top 10 was, you can see, Facebook and Philip Morris. With that introduction, I'm now going to ask Evyatar to proceed. And in order to do that, I have to stop sharing and I have to allow him to share. So I will do this now. Advanced sharing options. Okay, Evyatar, over to you.
All right, let's see if this works. Okay, thank you, Jeremy. And good morning, good afternoon, and thank you for joining us here today. My name is Evyatar, as Jeremy said, and I'm a patent attorney with JMB Davis. I'm going to briefly discuss the stages of the patent application process here in Israel and give you a general idea of what are some of the milestones you can expect throughout this process. So, like in most other countries, a patent application can be filed in Israel in one of three ways. First, filing, the Paris Convention, or a national phase filing from a PCT patent application. Important to note is that Israel is a 30-month jurisdiction for a PCT filing, so it is pertinent to pay attention to the dates when the PCT period expires. What you need to file in Israel, again, if you briefly take a look at what is listed here, you can see that what it is required is pretty much what would be required in when filing with any other patent office. One thing I should highlight is that when filing the patent application, it is possible to file a special examination request, such as a modified examination, a PPH, accelerated examination, or slowing down the examination. And that will actually be discussed in greater detail during Avram Hermon's presentation later on about the speed of your examination. The next step, once you've filed a patent application, it is normally published within 18 months from the filing date or the priority date in the case of a Paris Convention filing. In the case of a PCT application, when the Israeli patent application is a national phase filing, it is usually published within 45 days from the filing of the application. After the patent application has been published, the IPO, that's the Israel Patents Office, will mail out a notice prior to examination. Also, you will probably hear people refer to it as a Section 18, because that is its section under the patent law here in Israel. And this is a correspondence from the IPO requesting that the applicant provide any known prior art, any relevant correspondences from other patent offices during ongoing examination of the corresponding patent applications. And as well, this is one of the times when applicants can choose to file a preliminary amendment to the application, such as claim amendments to make them more compatible with the Israel law, as Mike will discuss when discussing amending claims from the US practice to Israeli practice, specifically for treatment. After responding to the notice prior to examination, a first office action will be mailed out and received about 6 months after filing the response. Here, an office action is an office action. They change very little from country to country. You are expected to be able to deal with rejections of patentability, drafting issues with the application, figures sometimes. What should be noted is that there's a 4-month extendable deadline to respond to office actions, as well as an option to extend that term for 4 months upon paying the necessary extension fees. Once the examiner is satisfied that there are no more grounds for rejection or objection of the application, a notice of allowance is mailed out with a request to pay publication fees for the publication of the application for opposition. Opposition period is 3 months. What is important to note here in Israel is that the opposition period is a pre-grant period, meaning it is prior to the issuance of the patent application, which is important to note because at that time there is still no patent protection for inventions disclosed in the patent application. Once that period is completed and no opposition has been filed, and the patent will issue, and 3 months from the issue date, renewal fees will have to be paid, and for different periods as listed below in the slide. And you will have a patent until the expiration of the patent term. And all the best and good luck. And thank you. And back to you, Jeremy.
Thank you. Thank you, Vitar. So
let me stop the share 1 second.
there we go. Okay, so without further ado, Mike, I just remind everyone that while Mike heads up our US practice, he's not up at some unearthly time in the morning. He's actually in our office here in Jerusalem. And Mike, over to you.
All right, thanks, Jeremy. So first, thank you all very much for joining us today, whether it's morning or afternoon or evening. We appreciate you joining us. My name is Mike Hammer. I'm a partner here at JMB DAVIS BEN-DAVID. I'm a US attorney and a US patent attorney. And I specialize in biotech, and I'd like to spend the next few minutes in a more biotech-centered area of Israel practice, but don't worry, there's some general practice tips sneaking in here as well. So if you're not always dealing in biotech, don't worry about it. It won't be completely a snore for you. One of the questions which we most frequently get from clients or potential clients when they want to file an Israel patent application is, can you take a look at my claims in the application that we're claiming priority to or doing a national phase entry of? And can you let me know if it's those claims are conforming to Israel patent practice? And specifically, the area that often has the most to do are methods of medical treatment. There we go. Like most countries outside of the United States, your standard method of medical treatment, your standard treatment method, are not patentable in Israel. And under Section 7 of the Israel Patent Law, it's very specific, though. It says that methods of treatment of the human body are not patentable. So this begs the question immediately, well, what if I have a veterinary treatment? Well, I think that those types of treatment methods are perfectly fine. So we're really thinking about human therapies. Here I have shown one of your standard bread and butter methods of treatment. Here it's a method of treatment of prostate cancer comprising administering to a subject a composition comprising a compound of formula X. There you go, a regular method treatment. Like I said, that claim is not patent eligible in Israel, and in order to be so, it needs to be reformatted to your standard composition for use claim, which I have presented here as well. A composition comprising a compound of formula X for use in treatment of prostate cancer. Several years ago, it was still possible in Israel to use your classic Swiss type use claim, but as of already several years ongoing, those claims are no longer conforming to Israel practice, and it must be the standard composition for use. So that's one thing to keep in mind. Along with what types of claims are conforming or not conforming, the other question which we get, and it's part of this overall question, is, well, when do I make those amendments? If I have those types of claims which need to be amended in my application, or to a greater question, if I have any preliminary amendments that I want to make in my application, when do I do it? And as Evyatar said, there are several stages over the course of an Israel patent application where you might consider making an amendment. Of course, during examination, you amend claims in response to an office action and a rejection from the examiner. And as you would expect, if there is a method of treatment of humans in your patent claim set, the examiner will reject it under Section 7 and will ask you to either delete the claim or to reformat it into a conforming format. Of course, these claims can be amended at the time of application filing, but personally, I think that for most cases, I would recommend that type of amendment be done at the notice prior to examination. And the reason for that is because, the notice prior to examination often comes, the space between the application filing and the notice prior to examination is often the longest amount of time that you need to wait over the pendency of the Israel patent application. And during that time, many of our clients, they have different developments, or their priorities might change, or they have other things which they're thinking about to do with their applications. And so that's a useful time to really just let the application sit. When the notice prior to examination comes around, not only can you reformat your methods of treatment into acceptable compositions for use, but the claims as a whole can then be amended to best suit the needs of the application at that time. Couple of other things that go into this. As Aviatar mentioned, and as Avraham is going to mention later on, there are certain examination procedures. Some of them are general and you know about, I'm sure, and some of them are specific. And these are used for either accelerating examination or getting a special type of examination under Israel practice. One of these, as Avram will go into greater detail later, is we call it modified examination. It's examination under the Israel law, section 17C. But the thing that's important for this discussion is that to use modified examination, it's necessary to have identical claims in Israel to a granted patent elsewhere in the world. Those claims must be identical so that a method of treatment which is granted in the United States does not qualify as an identical claim under the way the examiners interpret section 17C. And those methods of treatment cannot be used to support a request for modified examination. On the other hand, using the patent prosecution highway, which I'm sure you're all familiar with, in Israel is very similar to as it's used around the world. So all you need is a corresponding claim in order to support a PPH request. So if you get a positive examination report from the USPTO on a method of treatment, and you want to use that positive examination report, that positive office action, or even a notice of allowance from the USPTO to support a PPH request, you can do so in Israel for a composition for use. And that's my little story about treatment methods and Israel patent practice. And thank you very much for your time. If you have any questions, I'm happy to get them either by email or at the end of the presentation, and I'll send it back to Jeremy.
Thank you very much, Mike. I assume we're going to unshare. Excellent. Thank you. So just before we proceed to Avram, I was reminded of a very well-known phrase, show me the money. And in fact, it appears in various different places, none of which terribly serious, all to do with entertainment. Seems there was the movie Jerry Maguire in the 90s overused that phrase, but it sort of became stuck after that, having various TV shows called Show Me the Money, or it was generally quoted. But of course, the truth is that does represent a certain requirement that we all have, and that is show me the money. And again, leaving a little bit in suspense here as to how much money we can be shown, or how efficient the process of getting your patent in Israel can be, both in terms of money but also time. But before I go into those numbers, I'm going to ask Avram to present. And just one reminder, any questions that you have, please feel free to submit them. And obviously there'll be time for questions for a short time at the end of this session. So without further ado, Avram, please take it away.
Okay, I'm sharing screen now. Okay. I'm going to be talking about changing speed of examination in Israel. I think when considering patent protection in various jurisdictions, one of the questions that people ask is, okay, I can start the process, but when is it going to end? How much is it going to cost me? So this is going to give some clarity in terms of how long this process takes and how it can be modified. So first of all, what is the standard speed of prosecution in Israel? Luckily for me, in June of this year, the Israeli Patent Office released a report, as it does periodically, describing the situation in the Patent Office regarding examination. Examination is expected to slow a little bit because some of the examiners were not working over this pandemic. But more or less, this gives an accurate picture of how the Patent Office has been operating for the last number of years. The first office action can be expected within between 27 and 45 months, depending on the field. Some fields are faster and some are slower. It happens to be that pharmaceuticals and chemistry are the fastest, being at about 27 months. And mechanical inventions are the slowest, being at about 45 months from the time of filing in Israel until receiving the first substantial office action. The Section 18 requirement, which was mentioned before by Aviatar, will usually be sent 4 months before the examination will begin. Examination begins after the response to the Section 18 disclosure requirement is sent in. One exception to this rule is divisional applications. If you file a divisional application and the parent application is allowed, then the divisional application will be shortly thereafter examined and will not have to wait the full 27 or 245 months. Sometimes an applicant is interested in delaying prosecution for a number of reasons. How can one do this practically? So one practical way is by filing a late response to the Section 18 requirement to the Israeli Patent Office's request for disclosure, and that can be delayed by 6 months. So that can effectively prevent the prosecution from beginning. And in addition to that, the Patent Office can receive a request for delaying examination, and usually this is given for up to a year at a time. And one reason to do this would be to wait for other patents that are close to allowance or close to grant to be granted in order to do modified examination, which we'll talk about in a few minutes. How would you speed up prosecution? How would you make prosecution go quicker in Israel? So one way is by starting early. Starting early in Israel, if you want a patent and you know when you start the patenting process, you know that you want protection in Israel, you could file a priority application in Israel. Your first filing would be in Israel. And you would request a request to accelerate the examination. And the Patent Office essentially guarantees an examination to start within 3 months. So you get an office action from an official patent office within 3 months of filing. And this can be advantageous to applicants who are interested in patenting an invention worldwide, and they're not necessarily certain about the patentability. So they can draft a patent application, get this procedure of fast examination, and then by the time that the PCT is filed, they'll have some sort of certainty about their chances of patenting this invention, at least by the Israeli Patent Office standards. Another possibility would be to enter the national phase rather than at the 30-month deadline, or any time earlier before the 30-month deadline. You get a quick start of getting into line in the Israeli Patent Office. The applications are ordinarily examined by a first in, first examined type of regimen. Another possibility is to speed up examination once examination has started. And there are a number of categories to this. One of them is called green inventions, which are inventions that are related to protection of the environment or being environmentally friendly. The Patent Office will allow cutting the line of applications and going to the head of the line for these types of inventions, and this is free of charge. Similarly, in a recent announcement from the Patent Office, any inventions which are related to coronavirus, COVID-19, can be also accelerated according to this program, free of charge. The Patent Office does not charge any fees for this, and we've accelerated an application using this program. Another possibility is what's called a request for quick examination, and this allows the applicant to start prosecution earlier and to begin to make the process go quicker. This happens this is allowed by the Patent Office in certain situations that the applicant can show that there is a need for faster examination. For example, if there is potential infringement, the applicant will want a patent quickly, and the statement will be made to the Patent Office. Another possible scenario is if the applicant is the inventor and he is above 65 years, he can request this. And another method of speeding up examination is through the PPH, the Patent Prosecution Highway. And this is common in a number of different countries, and it allows an applicant to request that the examiner look at allowed or granted claims elsewhere and to show equivalence between the Israeli claims that are pending and those granted elsewhere. Important to note that even a positive PCT search report can be a basis for the PPH. So I've had situations where I've had a positive PCT report, requested a PPH based on that, and within a short time after international phase, the application can be quickly examined and even allowed. And one of the most commonly used methods is what's called modified examination. And this is what we know as the Section 17C of the law, which has been mentioned earlier. And here is a listing of all the countries which can be relied upon if the claims are essentially copied in Israel based on granted patents in other jurisdictions. Allowance is not enough. The patent has to be granted. Once the patent is granted in one of these jurisdictions, then 17C can go into effect. And it's important to note that an examiner is not required to allow the patent based on modified examination, based on the examination done elsewhere in one of these other jurisdictions. He can, but he has the right to do his own search, reject his own rejections based on the prior art that's already been cited. And sometimes that does happen. I've had an experience where that happens. So this is my last slide. I just wanted to point out Jeremy has quoted verses from 1800 years ago. This get-together where we have over 40 people signing in together from all over the world to hear people sitting in Jerusalem reminds me of a verse from 2,700 years ago, time of Isaiah, chapter 2, that the law will come out from Jerusalem. There was talking about a different sort of law. Here we're talking about patent law, which probably wasn't in existence then. But nevertheless, I'm reminded of that, and I feel fortunate to be part of it. So thank you for listening. And if you have any questions, feel free to reach out.
Okay, Avram, thank you very much. Apropos questions, I noticed that Rob and Judith have sent in questions which we will be relating to afterwards. And now I will try and see if we can find that money that I mentioned by continuing. I think this is where we're supposed to be, I hope. Yes, do you all see the slide? Yes, okay, good. Okay, so this is it, we're done. Well, not quite. You'll see there are numbers here, but at least the numbers above the curve have the dollar sign before them, so we can assume that's money. And the numbers beneath are time. Time from national entry to grant, normally. When I say normally, what I'm referring to is average times based on the particular processes that I'll mention, tying back into what Avram discussed, and provided that there is no opposition filed. Eviatar mentioned that in Israel we have a pre-grant opposition. It has its advantages and disadvantages. I personally feel that it's a fair way, if you're going to have an opposition system, at least let it be before the grant. Otherwise, you can be in a position where, for example, you're in Europe, where you have a granted patent, and then sometime a little bit later, you can be pulled back and say, well, actually, it's granted, but maybe not. In any event, that's a matter of maybe for another discussion, another time. That's the situation in Israel. Now, to put some labels on these numbers, this really does sum up more or less everything we've been talking about in practical terms. I would add that and I think this is clear to every patent practitioner, or everyone who is engaged a patent practitioner, that a major portion of the fees paid are the attorney fees in prosecuting applications. And those attorney fees are obviously invested in reporting and analyzing office actions. Even if we receive, in our case, we receive instructions from a foreign associate as to how to respond, there is always some time that needs to be invested. And this, therefore, explains why, and again, this is an average case, is actually an average case in the life sciences, where the total cost, and this includes also government fees, which are not terribly great, they're a minor proportion of this. This $9,500 I'm showing on the left for a normal examination assumes that you have you have a response to the notice prior to examination, a couple of rounds of prosecution, and then before we get the notice of allowance, we get a notice prior to that, during which we have to meet certain formalities. Very often the most major part of that is mentioning prior art which came up during prosecution, mentioning it in the background. But nonetheless, that notice will come. And so this $9,500, again, is an average sum. And again, on average, in an average case, it can go to as long as 7 years from national phase entry to grant, if no steps are taken to shorten the process. One of those steps that we've talked about, Avram mentioned in detail, is modified examination, section 17C. This also, as he mentioned, is based on granted claims from one of the qualifying jurisdictions. And in most cases, a request for modified examination will be successful. Based on our experience here, I would say in more than 80% of the cases, in a non-life science application, the modified request or request for modified examination will be allowed. Which means, and what that actually means is the claims are adjudged to have met the criteria for novelty and inventive step. That means that in 20% of the cases, the examiner has looked at the examination that was done in order for the granted case to become granted in the parallel jurisdiction, and found that, in his opinion, either some prior art that was applied was not applied in it properly or rigorously enough, or he has found additional prior art which he feels is at least as relevant as a prior art that was formally cited. But as I said, non-life science cases, you're talking about 20% of the cases where that would happen, that the request for modified examination is turned down. In life science applications, you're talking about, on average, I would say closer to about a third of cases like this. That's just important to bear in mind. It's not a slam dunk. On the other hand, it does give a certain, I would say, feeling of security or of assurance that it is not a rubber stamp. Modified examination is not a rubber stamp. It is something that is enshrined in the patent law, and we're not sort of getting around the system. It is a window that the legislature in Israel has opened, inviting anyone who qualifies to go through it. And because there can be a rejection of this request, when it is allowed, which again is the majority of cases, it is correctly considered that the examination based on novelty and inventive step has been conducted properly. The most important thing in terms of time and money, though, is that it will save, again, on average, about 3 years, and it will save more than half of the cost that it would otherwise that would otherwise be entailed here. If you then go to modified in combination with PPH, then things become even quicker. Essentially, certainly for those cases where the modified request is accepted, doing PPH it doesn't change the process except to speed it up. And that speed, obviously, you can see that again on average, you'll be saving an additional 2 years. You won't be saving that much money. It'll be around about the same. But I think that the most important thing is that while the figures that Avram presented initially in terms of standard examination are a little bit alarming potentially, the law in Israel provides for various ways to slash costs and to reduce time very, very significantly, and which is probably the reason why most of our clients, where this sort of thing is available, will opt for one of those ways. I would add as well, just to underscore this, sometimes it's worth waiting a little bit of time. I've talked about filing a request for delay. It's worthwhile investing that additional time, and extension fees will be payable, but they're relatively low. Time invested in waiting can produce very, very good results in slashing the prosecution costs, even though you may not end up with 2 years, maybe 3 years, but it's certainly well worth doing. Okay, so this actually finishes this part of the seminar, which is all the presentations. I would actually like to come back. I will stop sharing now so that we can all see each other. I see. Okay. Yes. One thing I wanted to say before we get on to, actually I want to get on to questions now. I have 1 minute. Right. So Rob Doherty from the UK asks, do claims benefit from provisional protection based on the published Israel claims? The answer to that, and obviously Avram Eviatar, feel free to jump in, or anyone else that has an opinion which is contrary to what I'm about to say. The answer to that is, as in most jurisdictions, once the claims have been published, there is a certain amount of protection given, provided that the claims that are granted are substantially the same as those initially published. Bearing in mind that the claims that are granted are normally somewhat different, it's by no means, I've had actually no, I would say, personal or vicarious experience. I've not actually heard of this protection being applied. Does anyone want to jump in here? Everyone's muted.
I will add something here. There was a case a number of years ago in Israel having to do with one pharmaceutical company suing another based on a patent application. And one of the sections of the law that was cited as basis was unjust enrichment. And the decision came down that if you have a patent system and there's a patent application that's pending, that the only sort of legal recourse that you have is through the patent law, not through unjust enrichment law. It was kind of an interesting sort of case where the power of a patent application that hasn't been granted was tested. And that's, I guess, similar to this question here.
Yeah, exactly.
I guess my question was provoked by Mike's comment about when to amend. If you're taking a method of treatment claim based on a US patent application, for example, it seemed to me, looking at the process, the patent published prior to when examination would start out of that PCT application, and therefore is it not sensible to have at least some claims on file that are patent eligible, not method of treatment, and have a likelihood of being enforceable and likely to grant? I mean, a lot of things there, but that was the basis of my question.
So I think that just to jump off from that, you're absolutely right, and I think that part of the overall, I'd say, consideration about when to amend is really what your client is going to have in mind as their destination. And if their destination is going to be changing a whole lot, or potentially changing from the time of filing until the time of the hoped for obtained claims, then I think it's worthwhile to wait. But on the other hand, if it's a situation similar to what you're thinking of, that the client knows what they're going for, they have them in the claims, those claims, the ideal claims really aren't going to change so much from filing, then absolutely, I think you're right that filing the amendments from the get-go is a good idea.
Thanks, Mike.
I just want to add, before we continue with the questions, which we will, I see that we're coming up just to the hour, and I understand that some people will have to go. Again, just before the questions, I want to thank everyone that has joined us. Stay with us for as long as you want when we go through the questions that have been raised. I hope we'll do this again sometime. In the face of the inability to actually travel, and many of us who are, Vika, I see you smiling there, many of us who have met each other in various places, but in the same place at the same time, we don't know when we're going to be able to do that again. So in place of that, this is certainly a quite a nice second best. Just one other thing before we get back to the questions, is that the Jewish New Year is surprisingly just around the corner. It's in a couple of months. There's also an age-old saying that we wish each other, and that is that so literally the curses, the bad things of the outgoing year, they should be left behind, and the new year and its blessings should begin. And I always say that, well, let's not forget the blessings of the outgoing year. This year in particular has been very, very difficult, difficult beyond belief. We could not possibly have imagined what would happen, all the hardships that the entire world has gone through this year. Many places more than others. Certainly in the UK, it has been, again, it is, I don't think words could adequately express the sympathy, the empathy, the feeling of identity with what you've been going through there. In Israel, we're now experiencing a second wave. So we're not out of the woods yet. I know that in India as well, things have been recently exceedingly difficult. We're all in it together. The only qualification to be affected by this is to be walking upright on two legs, and none of the rest of it matters. So having said all of that, we know that very often in the face of adversity, what drives humankind on is our creativity, is the ability to produce good things in the face of that adversity. There has been a tremendous amount of, I would say, mutual self-help around the world in basically every society because of difficulties that people have had. And on the other hand, we have seen that technology has really come into its own, again, allowing us to get together like this. And we should not forget the good things that we picked up along the way and take those forward. Hopefully, the pandemic will be behind us as soon as possible. And again, the good things should move ahead, and our lives should become enriched, at least in a minimal way from this period. Anyway, so again, anyone that has to leave us at the moment, thank you for joining us. We'll now continue with the questions. Judith Abrams, you asked a question, do you recommend using modified examination or PPH or regular examination? There's no, as with everything else, there's no one size that fits all. If you are happy with claims that you've received in a qualifying jurisdiction, such as, again, US, EP, Japan, Australia, there are a few others according to, as per the list that Avram posted. If you're happy with those claims, then I would say that, and you have, I would say use them. If you're slightly uncomfortable with them, because maybe, let's say you've identified some prior art which didn't come up, then I would say you would not want to rely on the examiner finding that prior art. I would say that in that sort of case, go the normal route and make sure that he considers the prior art. I'd actually add here that what I don't think was mentioned is that a recent innovation in Israeli practice has been the facility for re-examination. After you get a notice of allowance, there's a very rigid 3-month period to pay the issue fee. There are no extensions available. That has to be paid. Otherwise, the application will become abandoned. However, it is possible in place of that, if you have come across some additional relevant prior art that you want the examiner to consider, you can then submit that and ask for the examination to be reopened. So again, it all depends, Judith, on what the situation is. But I would say 9 times out of 10, if you have claims that you're comfortable with, then you would probably benefit by using modified, and if the timing works, also PPH.
Right, thanks. You really answered the question after I sent it. Can I ask a follow-up question?
Go on.
For instance, you said the claims for modified examination have to be identical. Say you've got a granted application with method of treatment claims and composition for the use of claims. So in Israel, you would be deleting the method of treatment claims. So can you go for modified examination where you're deleting part of the claims?
I'm going to turn that over, because it's life sciences, I'm going to turn that over to Avram and Mike.
Okay, yeah. So in modified examination, you don't have to have the exact overlap of claims with a granted patent. If you have fewer claims, then that will also work. So you could choose those claims which are eligible for patent in Israel and then proceed accordingly.
Thanks. Thanks very much.
Okay, next question, and this is from Professor Sodipo. I would actually add, are you with us still? Yes, you are. I would actually add that I believe, if I'm not mistaken, I believe that I first met you at an Inter meeting many years ago. I think it was, I don't know whether you remember this, but I think it was in the company of Professor Jeremy Phillips.
That's right.
Yes, and anyway, so and over the years we have bumped into each other now and again, and I'm actually thrilled that you're joining us from Nigeria. So you're actually the representative of the African continent, and it's lovely to have you with us. So again, this is actually, I'm going to kick this question up to Avram and Mike, and maybe Avram with his formerly background from Teva will be able to respond to this. Do you require local trials for medication that's been approved abroad?
So the answer is the Israeli health authorities, and I'm speaking from my experience at working in-house in Teva Pharmaceuticals, which is Israel's biggest drug manufacturer and one of the biggest generic drug manufacturers in the world. I was at Teva on the innovative side, and we were involved closely with clinical trials. Most drug companies will file for approval for their drugs in the big markets and then proceed to other smaller markets such as Israel. From what I understand, and this isn't, I don't work with this firsthand, but from what I understand, that most times an approval in the US will form a basis as an approval in Israel, but it's not just a rubber stamp. You don't automatically get approval. The Israeli Ministry of Health does do this, its own determination. That being said, I don't recall ever seeing trials in Israel being required specifically for drugs that have been approved overseas in other competent health authorities.
Thank you very much.
Okay. Simon, are you with us? I think Simon may have had to.
No,
leave.
he's here. He's at the beach.
Still here.
Oh, you are here. Okay. Obviously, I need to get a bigger screen. Anyway, so Simon, yes, you're not at the beach. It's too cold for that. It's winter where you are, winter in Melbourne. Okay, so the question was, is filing a priority application in Israel and requesting expedited examination also an option when the applicant or inventor is not an Israeli? So Avram, you should, I think that you can definitely take that one.
I have never seen such a requirement. It does not have to be an Israeli applicant or entity doing this, and I think this is a great strategy for international, non-Israeli applicants who want protection worldwide. If they know that they want Israel as one of their countries that they want protection in, a search report in 3 months can bring you to another round of examination, some give and take with the examiner, and within 12 months, by the time you would ordinarily be filing a PCT, you could have a granted patent in Israel. And that's my experience from doing this, that we actually have a granted patent in hand around 12 months, sometimes a little bit longer because there's the 3 months period between publication and grant. And then you can proceed to either national phase filing directly or PCTs in other countries, and then use the PPH. And imagine going through a rigorous examination in one country and then sailing through other jurisdictions rather quickly based on PPH. That's a great thing, and that cost is not very high for requesting accelerating examination. I didn't mention it in my talk, but we're talking about Israeli Patent Office fees of roughly 1,000 shekels, which comes out to it's about $300 in US. That's about the cost of extra fees you're paying for expediting the procedure. It has to be made clear that this is only allowed if your first application ever filed on this invention is in Israel. And in other words, if you file a provisional application somewhere, let's say in Australia or in the US, and you abandoned it, you are no longer eligible for this process. Even if you're not claiming priority from another application, you have to essentially send in a declaration saying, this is the first application on this subject matter that we are filing. So that's an important message. So I would like to see foreign associates turning to us for this as well, if they're interested. And I think there's a lot of potential for saving money for the client, saving time for the client.
I just actually add that there is a possibility of requesting accelerated examination based on specific reasons, which requires a declaration attesting to those reasons. Normally, those reasons would be connected with commerce, with business, that there's a real threat of potential infringement, in the short term. Even though such requests have been getting, I would say, fewer over the past few years in terms of my own experience, certainly over the past couple of decades, we've handled quite a number of such requests based on business reasons, and they have all been accepted. What the story is, I'm not sure I filed one of those in the past year or two. So, of course, we know that sometimes things change, but it's certainly worth considering. Generally speaking, this is not going to be for a pharmaceutical type patent, but it's going to be more for, shall we say, a product related or other types of technology, where the time of development and time to market is normally going to be sooner. Okay, Aaron, this one's for you again, I think. Are claims based on a dosage regimen patent eligible in Israel?
Okay, thanks, Rob, for this question. The answer is yes. We've had these sort of claims. Obviously, methods of treatment, as mentioned by Mike, are not patentable, but there are ways to draft these sort of claims. We can discuss it offline if you're interested in examples, but I've had experience with this sort of claim in the past. Okay,
so the last question is from Mr. Hussein. Yes, you're still here, good. Asking, and Aviatar, I think this is going to be a question for you.
Right.
How hard is it to get software patents in Israel? Right up your street.
Right. So thanks for the question. Software patents, Israel has adopted the EPO stance on software patents, which is also adopted by other countries such as China, which is that software patents are, software is ineligible subject matter for a patent. However, like every rule, there are exceptions. In this case, if there is some integration of hardware, then it is patentable. And that is one way to overcome it, showing some way that the software is performing on a hardware device, such as a processor or a computer server. That is one way that we are able to overcome that. Yes, you are limited because you're connecting it to something tangible, such as a computer, but at the same time, you're still getting a patent for the software, in a manner of speaking. And that is pretty much the same as an approach that we would take if we were responding to this issue in Europe as well as in China, which was they amended their law a couple of years back to also be pretty much in line with this approach and the European approach to software patents.
So I have a question over here. Like the European is quite tough. Hi, I'm Muzammil Hussain. Yep. And European is quite tough, whereas US is fairly okay. And in light of the allies and other things which had happened in the past, right now the USPTO is quite cooperative. So if you have some granted patents from US, so we do a lot of work in US. Do we stand a chance that we may get an allowance in Israel as well?
The US is much more difficult of a standard because of the way the law is changing there based on the Supreme Court decisions. I'd say it's a less hard rule there. In Israel, it's a lot closer to the European approach. So it would be a little bit more difficult, but at the same time, unlike in the US where, as you can see from a lot of if you read on it, a lot of opinions and guidelines from the USPTO in this matter, there's still some lack of clarity sometimes in certain situations as to what is patentable in software and what is not, whereas in the European format, it's a little bit more clear. It's a little bit more difficult, but there's more clarity as to what is and what isn't patentable, and it allows drafting the claims in a manner that allows complying with those requirements and still getting a patent, and not having to do unnecessary office actions where you're arguing with the examiner about an interpretation of the law. I think that's the best way to explain
The only
it.
thing I would add to that is that, say, if you have a U.S. claim, which under some of the more recent examination guidelines truly integrate that software or that process into hardware or into some sort of a real-world application, then I think that type of a claim, based on what Evyatar is saying about really real integration with a physical component, I think that would probably be okay here. Evyatar can tell me if I'm going off course, but our experience with with the U.S. type claims where they are requiring real integration, if you have something like that and that's granted, that could probably be a good basis for a claim here.
Jeremy, if I can just hop in here a little bit.
Yes, Bruce. Bruce, it gives you more time to prepare to answer Vicky's question, which
okay.
I was maybe going to get around.
Going back to the 1970s, when we started to see software patents, none of us actually knew what to do because it was such a new field of technology, and we started writing them as method claims. And throughout the 70s and early 80s, in most cases, we did not get a rejection on patent eligibility. Starting in the 90s, people started writing the claims differently. And of course, in that period of time, these type of patents became far more prolific because technology exploded. And looking at the cases that have come down specifically in the US and to a lesser extent in Europe, one of the things I see is that the key to answering the question as to whether software or business method patents are patentable is how are the claims written. When people have come to me and said, is software patentable? Are business methods patentable? I always say to them, let's not deal with that question. Tell me what your invention is. And if you're creative and you know how to write claims, not all the time, but a good percentage of the time, you can avoid that issue. So the key is, how do you write the claims? And that's the issue you should focus on.
Bruce, thank you very much for that. We're going to have to, again, move on a little bit. I think actually the situation, Muzammil, I think you're really referring to, is where the claims are written, you have a patent or are going to get a patent. Can you then use those claims in Israel? So we're further along the pipeline than the initial patent drafting, but Bruce, your points are definitely very well taken. I'd like to get to the last question, which
thank you so much. Yeah.
You're welcome. Yes, a question from Vicky. Can you make any general comments on patent enforcement? Pro-patentee, skeptical on inventive step, speed, costs? Okay, I'm probably not going to give you a lot of satisfaction here, Vicky. The truth is that in Israel, there is very little litigation surrounding patents. Most of it, and Avram may have an insight here or two, most of it is normally about, or shall we say, between various pharmaceutical companies. So it's difficult to say whether it's pro-patentee or not. I would say that because there's so little of this type of litigation, and because the judges, know so little about patents to start off with, they are often educated by the attorneys, by the lawyers appearing in front of them, and that can only happen. And this is based on the story that I heard from one of them, provided the judge actually stays awake. So, so the answer is that other than that, I can't make too many general comments. I don't think it's pro-patentee. I don't think it's anti-patentee. I think that it will depend on the case. I think that everyone is always skeptical on inventive step. And again, bearing in mind the non-patent background of judges, they're no different in that respect than other people. Many people, I think some of the entrepreneurs that we deal with as well, they themselves are skeptical on inventive step. What I've done is trivial. How can it be patented? And as Bruce said before, forget about that question. Just tell me what you have. You're paying us money to help you. Let us help you. One thing I can tell you is speed. No litigation is particularly fast, nor is it particularly slow. Litigation we have been involved in other types of IP is normally going to be finished within a year or two. Costs, certainly compared to Europe and certainly compared to the US, are much, much lower. They're probably more comparable with, I would say, what used to be the costs in China, but even there, the costs are starting to get a little bit higher. So again, I told you I wasn't going to give you any satisfaction on that, but that's unfortunately that's what I can give you on that.
No, that's great. It's just I had a client ask about enforcement when choosing countries, and if you don't get a little bit of information about enforcement, then you just can't even help them choose where they're patenting. Right.
The one thing that I can tell you is that we have a litigator on our team, a fellow named Arya Rife, and he is someone that I would rather have on my team than on the other side of the bench. So if you do actually have any specific hard concrete questions about that, we'll be certainly happy to connect you. Last thing I just want to mention is to do with bureaucracy, which again, no one likes bureaucracy, no one likes dealing with questions about bureaucracy, but I think these two things are actually going to be, for anyone who's not familiar with Israeli practice, they will be music to your ears. One thing is that, and I think Eviatar mentioned this, but it's worthwhile emphasizing, applications are filed in English. We often get inquiries as to what translation costs are going to be. The only translation costs are not of the application, but the costs when we translate official actions that we get from the Patent Office, which are issued in Hebrew. And our standard practice is to provide a formal translation and then to provide a letter of explanation to a greater or lesser extent. And the other thing is that these days, and it's been the case now for several years, yes, we need a power of attorney form, but on the other hand, all we need is a digital copy. In fact, we have nothing to do with a paper copy. We would just scan it and send in the scan. So, and I think all documents, Dodiva, correct me if I'm wrong, all documents are now filed digitally. Is that correct, Dodiva?
Yes, yes.
Good. Okay, Dodiva is the face on a lot of the formalities involving things that we file and so on. I think, so having said all of that, it was good to, those of you that had the cameras on, it was good to see you. It was good to spend time together with you. And we should do this again sometime. I would love to be able to say that I'll buy the drinks. And everyone, please stay safe. Have a good summer, Simon, winter. And let's put this all behind us as quickly as we can, and just do the important things in life, one of which is patents, but it's not the only important thing. Anyway, have a good day, everyone, and we'll see you again sometime.
Thanks so much.
Bye. Thanks so much.
Thank
Very
you.
nice.
Thank you.
Thank you.
Thank you so much.
Bye.
Thanks, guys.
Bye-bye, Masaru.